the flexibility in the formation of company now in Nigeria, unlike before under the previous Companies and Allied Matters Act, where one person cannot form a company. Now, when you look at the provision of the Act under Section 18, you will discover that two or more persons can come together to form a company. But note that the formation of a company must not be for an unlawful purpose. You cannot come together for the sole purpose of committing illegality. You cannot come together to form a company in order to commit crime. The law does not permit that. Now, when you go further onto sub 2 of this section 18, you will now discover that yes, under this new comma, one person now can form a company. But for one person to form a company, it must be a private company. Now, to be able to take that decision that yes, I want to form a private company, you must also have the basic knowledge of what constitutes a private company. Okay, now if you go further to section 22 of the Act, you will discover what constitutes a private company. Now, a private company is that company that is stated in its articles of association that look, this is a private company. On the very face of that article's document, it will be stated there that look, this is a private company, so that anybody who is seeing the documents of registration of that company will know that yes, this is a private company. Now, when it also has to do with the property of the company, the assets of that company, assets that is over 50% in value of the assets of that company cannot be sold by that company without first seeking for the consent of the members of the company. Now, when it also has to do with shares of the company, it must be authorized by law, or it must be a situation where the member who owns or holds those shares has first offered them to members of that company before offering them to the public. So if you are a member of a private company, you hold shares there, you cannot offer the shares to the public without first offering those shares to those who are also members with you in that company. So it also, another restriction or another condition that relates to a private company is that when two persons or more persons hold the same shares, you cannot treat them separately. You must view them jointly. So when two or more persons, whether two, three, four, five persons who hold particular number of shares together jointly, you see them as a single member. So you're not going to see them as individuals, individual A, B, C, and D. They become one person in the eye of the law. Now, it is expected for you that is operating a private company to comply with these provisions under section 22 sub 2 of this act. Because when you go further to section 23 of the act, there are consequences for non-compliance with the provisions under sub 2 of this section 22 of the act. This is because where there is non-compliance, where you fail, where you default in observing, in complying with this provision under section 22 sub 2, the law will not see you as a private company. But the company can on its own, maybe when they see that yes, it was due to inadvertence on their own side, it was due to whatever reason that may be reasonable, okay, or any other person that is an interested party in the transactions or operations of that company can make an application to court. So it is for the court to actually look at the application, the grounds that have been stated, and if it sees that it is reasonable, the court can grant relief to such a person or to the company, notwithstanding the consequences already spelled out under section 23 of the act. Okay, so this is what I want to share with you today. I am sharing this based on the fact that some time ago, when I was discussing with one of my colleagues on how to form a company, she was insisting on getting other shareholders that will also sign to or undertake some of the shares of the company. When I now drew her attention to this provision that yes, it is actually possible for one person now to float a company. So there's no longer that restriction. If you have the money to run that kind of business that you want to run, you can open a private company. Okay, but you must comply with these provisions that the act has laid out to ensure that yes, in the eye of the law, you are actually seen as a private company. I hope you have learned something today. This is Xavier Law Essence, where we give you premium legal tips to help you make informed decisions, help you live informed life, and discover the best version of yourself. We'll see you again. Bye.